court is ready to proceed when you gentlemen are. You each will have 15 minutes, and you may reserve as the appellant up to 5 minutes for rebuttal.
Thank you, Your Honor. Good morning. My name is Bruce Wilson. I represent Daniel Strebler again. I've been trying for quite some time, as you already know, to get a court of competent jurisdiction to rule on the merits of Strebler's state law claims, the claims that are now or were recently before Judge O'Brien. Until now, I've not been able to persuade either the federal court or Judge O'Brien to accede to my request and render a final judgment on the merits of the state law claims. Strebler's had two proceedings. We call the federal proceeding Strebler 1 for shorthand, the state court proceeding Strebler 2, again, for shorthand. So what happened in Strebler 1? Well, Judge Adams closed the proceedings in Strebler 1 perpetually and has never reopened, and is not, I'm sure, about to think about the case again, ever. Judge O'Brien dismissed the case on the basis of the arguments in favor of a Rule 12b-6 dismissal and what started out to be an examination of my complaint, my drafting. It appears that in the absence of a final judgment from the federal district court, what else could Judge O'Brien do except look at the sufficiency of my complaint, which is what was being pointed out, or the lack thereof. So my complaint doesn't identify or describe any final judgment on the merits of Strebler's state law claims, an essential prong of a res judicata determination. Simply isn't there. There is no such judgment. I assure you, if there is, I would have produced it if I had any sense, and if not, I'm sure Morgan Stanley would have produced it. By the way, what they have supplied for the record in support of their motion are the three federal court orders, two by Judge Adams and the third by the Sixth Circuit, which approved his closing of the case on the opinion of the court. Judge O'Brien may have taken notice of, without directly saying so, are the three federal court orders provided by Morgan Stanley in its briefing to the trial court. Strebler contends that those orders, what those orders do not say, is more important than what they do say. However, before discussing those prior orders any further, if that's where we're headed, and I suspect it is, I want to offer some corrections, for the sake of argument, to the text of Strebler's state law complaint, which I drew. Paragraph 40, which seems to be where I met my Waterloo, as it were, may have misled Judge O'Brien, certainly not on purpose, to enter the judgment on appeal. The words, however, Judge Adams dismissed the case on September 7, 2012, which would have been an important event for other reasons, identified by me as DE 27, are inaccurate. No such order exists. In the same paragraph, my text again was, the judgment of the district court is affirmed. No prejudicial error in the judgment and proceedings of the district court are also inaccurate. I conflated two sentences in the district court, in the Sixth Circuit Court of Appeals. Affirmance. The complaint language conflates two paragraphs in the Sixth Circuit order, which I think you also have as a part of the record, which reads as follows: the court finds no prejudicial error intervened in the judgment proceedings in the district court. It is therefore ordered that the judgment of the district court be, and it hereby is, affirmed upon the opinion of the district court. That opinion was and remains, I don't like these claims. Judge Adams has a very low opinion of my federal claim and later of my state law claims. He makes no bones about that. But he did not enter judgment. He simply perpetually stayed the case. So, since I clearly wasn't going to get relief there, having thought about whether or not the state law claims survived and were viable, I filed the current case, which you have now on view. So where are we? Well, Judge O'Brien, argues with herself, I think, about whether or not her process will stand up. Her process of what? Of examining my complaint for the message it conveys or does not convey concerning a viable theory of relief under state law claims. But I must say, when she tries to apply, not finding the language she's looking for, I guess, in my complaint, she seems to go off the page, as it were, to find some support for the grava prongs for a res judicata judgment, which is what I think has been delivered here. It is our position that that was error, that indeed if the case had proceeded as she apparently anticipated on motion or motions for summary judgment, we could well have ended, I could well have ended up in the position I now find myself, with a judgment based on res judicata principles. There will be, if the case has a life beyond this court on remand, there will be, for sure, voluminous briefing and argument about what the district court proceedings really meant. Were the end of the line? Did they really dispose of the state law claims? Was there really an affirmance of the arbitration award that the judge made me follow? I could have defied him, I suppose, but I felt it was much better to take the remedy he offered, build my record, and that at his suggestion, then bring it back if I had something to complain about, which I most certainly did. But he simply had made up his mind he wasn't going to look. That's what happened, plainly and simply. So I sought another venue. I'm not doing too well there either, and I need your help to send the case back and do it right.
If I may, sir, is the fundamental problem that there was an arbitration award and that there's some that disagreeable with it?
Well, it would be troublesome if it had been given full effect, but the district court would not, no matter what he says he might do. In fact, that's the way Judge Adams couches his full attitude about it is, for all your bellyaching about what these forfeiture principles mean to your client, As long as a judge somewhere can find any reason to affirm the arbitration award, that's what's going to happen. But he doesn't do that. He muses about, you know, if I ever had it, this is kind of what I do. I think that's what he's saying. He just doesn't do it. Now, is he doing me a favor? I don't know. I don't think he liked my being over there. So I didn't go back again. I came to the state court, where the state court claims I thought were much clearer and much more forceful and much easier to prove. I think the question about forfeiture is there. I think that piece is not ever going to be very difficult. The question is there some justification for the forfeiture? Strebler's earnings are denominated as earnings. He did not agree to give them to his employer when he voluntarily left. He asked for them back and they wouldn't give them back. Well, if there's some justification for that, it's somewhere in the documents that Judge Adams wouldn't look at. I want a court, as obvious, I want the court to look at those documents. If he won't do it, I think the state court can. I'm sure Judge O'Brien will have no difficulty reading what's there to see whether this truly is a forfeiture, therefore unlawful, in a relatively simple case about giving the money the Strebler earned to Strebler, or not. I better save my 5 minutes for what I think is coming. But thank you for listening.
Thank you, Counsel.
Good morning, Your Honors. John Corwin on behalf of Applebee's, Morgan Stanley, and the Morgan Stanley Compensation Plan. This case, or this appeal, presents a straightforward application of res judicata. Contrary to what counsel for Mr. Strebler has argued, there has been a final decision. Mr. Strebler got exactly what he bargained for in his employment agreements. He bargained for an arbitration of any complaints he had against his employer. He got that. He got a final decision from an arbitrator, and under Ohio law, as both a matter of law and policy, that's entitled to res judicata effect. Mr. Strebler had his day in court. He had an opportunity and did in fact present the documents he wanted to present. An arbitrator heard those arguments, reviewed the documents, and came to a decision.
If I may, was it binding arbitration or non-binding?
It was binding.
It was binding arbitration.
To step back, I want to address a couple points that are, I guess, alluded to a little bit in the briefing, but not directly addressed. And the first is that res judicata can be decided in a 12b6 context. We have case law authority for that. We have a case out of the 9th District that says in admittedly rare situations where there's enough in the face of the complaint, res judicata can be decided on a motion to dismiss. We have that here. We also have decisions out of the 12th District, the 9th District, and other districts that say courts can consider other court rulings and can take judicial notice of those. So
That's what concerned me a little bit, as your footnote 4.
yes.
Where you say that the court may consider pleading copies of written instruments, and I know we ruled the exact opposite. So, does that have anything really, because I think your primary argument is that it's within the confines of the complaint.
Absolutely. I think this case can be decided on the face of the plaintiff's complaint, and obviously now is not the time for the plaintiff to be amending his complaint or changing the wording of the complaint. I added those documents because I think it is appropriate for the court to take judicial notice of them and look at them, but I don't think they have to. I don't think the trial court had to, and clearly from Judge O'Brien's decision, she did not consider those. But I think it's proper. The one decision I cited, I think it's the Likes case, it's not in a res judicata context, but the court does say that in a 12b6 context, it is proper to take judicial notice of other documents without converting it to summary judgment. I think the documents that have been attached add context, but again, they're not necessary. As a matter of fact, Mr. Strebler lost, and all of his claims, his ERISA claim and his state law claims, were dismissed with prejudice in the arbitration. But we don't need to get there. Mr. Strebler alleges in his complaint that there was a final decision. He says that Judge Adams compelled arbitration and said that he could come back after a final decision, and that's in fact what Mr. Strebler did. After the final decision in the arbitration, he went back to the district court. He asked the district court to reopen the case and also to vacate the arbitrator's award. He raised a number of arguments, including that the arbitrator didn't have jurisdiction, which he had previously argued and lost, that the arbitrator had abused his discretion, and a number of other arguments. The district court addressed those, considered those, and denied the request to reopen and to vacate. That decision was appealed, and that decision was affirmed by the Sixth Circuit. There doesn't appear to be any dispute in this case as far as the elements of res judicata. We're dealing with the exact same parties, the exact same claims, and the exact same transaction or occurrence. The only question that has been presented is whether there's been a final decision on the merits. And I submit that there has been. Again, there was an arbitration that took place. Mr. Strebler's state law claims were briefed, they were argued, and they were addressed, and they were ruled upon. As a matter of law, Ohio courts have recognized that an arbitration decision, whether confirmed or unconfirmed, carries with it res judicata effect. As a matter of policy, we need to apply res judicata to arbitration decisions. Otherwise, what good is arbitration? If arbitration is to be favored as a method to streamline litigation, to avoid costs and that sort of thing, we eliminate all of that if arbitration decisions do not carry any res judicata effect. A litigant who is unhappy with the arbitration decision can simply run back to court, file the exact same claims against the exact same parties out of the same transaction or occurrence, and seek a second opinion.
And if it were non-binding arbitration, one could in fact do that?
Potentially.
Okay.
Yeah.
But binding arbitration, you're stuck with it.
Right. And we also have the added procedural event in this case where, in fact, Mr. Strebler did come back to the court and did seek to overturn that decision, and that attempt was ruled upon, that was denied, and that was affirmed on appeal. So I think even if the court wanted to get into whether this is binding or not binding, whether it was confirmed by a court, I think we have, in effect, an affirmance by the district court of that arbitration. I think, again, on the face of plaintiff's complaint, we have all of the elements necessary for res judicata. There was a final decision. Strebler admits that he went to arbitration. There was a final decision by the arbitrator. The same parties are present. The same claims have been presented, and it's rising out of the same transaction or occurrence. There's a couple other points that Strebler made in his brief that I wanted to also address. There's some language in appellant's brief talking about actually litigated, directly determined. I think that language is inappropriate here, especially in a res judicata claim preclusion situation. Obviously, res judicata claim preclusion applies to claims that not only were raised but could have been raised, so clearly you don't have the requirement of actually litigated, directly determined. Nevertheless, we know from the arbitration that these exact claims were actually litigated. They were directly determined adverse to Mr. Strebler. There's also some reference in the brief to the district court sending this to arbitration based on the ERISA claim, and that is not the case. It was all of Mr. Strebler's claims, and it was due to the Form U4 that he signed in connection with his employment that required all claims against his employer to be arbitrated. I'm not sure exactly what appellant's getting at with respect to the ERISA argument. To the extent he's suggesting that the district court never had jurisdiction, that's not the case. Obviously, a federal court can exercise supplemental jurisdiction. It has authority to do that, and clearly by ordering or compelling arbitration, it exercised that supplemental jurisdiction to send those state law claims to arbitration. As a matter of law and policy, litigants should not get two bites in an apple. clearly litigants shouldn't get 3 bites in an apple, and that's exactly what's happening here. Therefore, we respectfully request that Judge O'Brien's decision dismissing this case on res judicata grounds be affirmed. And unless the court has any other questions of me, I will rest.
Just one question. Does it matter that this was a declaratory judgment?
No. I mean, it's the underlying claim is the same as.
I know I threw you kind of for a loop there, but we have some case law that talks about how, declaratory judgment is a unique creature and the court has to declare and here it dismiss.
I believe that would fall within, it's either, I can't recall, I think that's one of the claims was also asserted. I'm not aware of any authority that would suggest that res judicata cannot apply to declaratory judgment claims. And in any event, that would have been a claim in the arbitration that was fully decided.
Okay, thank you.
Thank you, Your Honor.
So there's just no way to avoid further discussion as appropriate to address the comments about the federal process. The irony for me here is that having been ordered to arbitration, both parties were ordered to arbitration. Morgan Stanley refused to sign the arbitration agreement. Strebler submitted to the court's order, submitted to the jurisdiction of FINRA, the appointed arbitration association, built his record, came back. I must say, at that point, if Morgan Stanley must have been conflicted. Since they hadn't agreed to the arbitration, they would have made a pretty poor showing if they asked, like I did, to open the arbitration proceedings and confirm them. Excuse me.
Didn't you just say that they refused to sign the arbitration agreement?
Yes.
So there was an agreement that was reached at arbitration?
No, I'm sorry. The agreement is FINRA will not engage in the process of arbitrating a claim unless you sign their agreement. So I added to, here's what happened, I added to their agreement the specific provisions in Judge Adams' order so they would understand that I would, and the clincher is, they want you to agree to make the arbitration binding. That's what they want.
But he said, I believe he stated that Form U4 that was signed by Mr. Strebler required all claims to be arbitrated.
That's what the form says. I don't think it applies. I lost that argument, to be sure. But I followed the dictate of the court. I went to the arbitration. We were given an arbitration agreement to engage FINRA. We paid the filing fee. I noted in the arbitration agreement before we signed it that, yes, I will comply with the FINRA rules and regulations about how you do this process. But if I'm disappointed, since I've been ordered to come here and didn't voluntarily come here, I'm going to go back to Judge Adams. And I gave them a copy of the court order. They asked me for it. They then proceeded with the arbitration. Morgan Stanley simply wouldn't sign the modified agreement to acknowledge what the court order said that drove us to FINRA in the first place. So now I get my, arbitrator's decision, which has no reasoning, which was okay under their rules. They're not telling me why they did what they did. They could just simply say claims denied, which that's what it is. Claims are denied. So the next opportunity that was presented to peer into all this was vigorously opposed by Morgan Stanley. Why not? They won. I get that part. But they could have, if they were so sure that the process was correct and that I was bound by it, they could have agreed with me to open the case and ask Judge Adams to confirm the arbitrator's decision. That would have been the end of that line for sure. But that didn't happen. They simply opposed and opposed and opposed. I think Judge Adams was probably sick of both of us at that point, and simply said, I told you before, I don't, he criticized my state law claims and my arguments and so on, but he didn't do anything more than close the case administratively. It takes it, as I understand from reading, it takes it off of his docket. He doesn't get criticized for having a case that's being unattended. But it has not been attended to for a long time, so I sought my relief where I thought I could get it in the Summit County Court of Common Pleas. The arguments that we have been constrained to make, I guess, back and forth to give this context, could have and should have been made before we got here. I would trust this court's judgment on a ruling on summary judgment if that was appropriate, but that process should take place with a little notice that we're going to do that in the trial court. That's where we could parse all these arguments and see whether or not the arbitrator's award was made final and that I have to live with it by some construction, which I'm sure they have looked, or said, look, high and low to find a construction that would achieve that result. But we didn't get that.
But you're out of time.
Thank you for listening.
Thank you. Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement. A written opinion will be issued and sent to both sides. And you can check on our website as well as the Supreme Court website where we release our cases. Thank you. Have a good day and try to enjoy the weather.